So this is your last mini lesson on the Bill of Rights, and this one is going to cover some other protections, things that don't really fall under the category of the First Amendment, which deals with, those freedoms, those RAPS freedoms, or those middle amendments, which largely deal with the rights of criminals. So these are some that kind of fall in another category of other. The first thing you're going to want to do is on your page 4, you're going to want to divide your paper into 6 sections. If you go ahead and do that, then you'll have a place to take all of these notes, and make sure you take good notes, because when I grade them, I know what I'm looking for, since, I made it. So we'll start with our Second Amendment, which is probably the easiest one for you to remember, because as you recall, if you're counting and you start with your thumb and then your second finger, you've created what looks like a gun. There's my favorite joke, the bare arms, the joke being, of course, that he has bare arms. Okay, I'm over the joke now. The Amendment 2 falls under a category that actually 2, 3, and 4 all do, that were really inspired by very specific events during the American Revolution. So specifically here, we're talking about how when they were deciding to fight in the American Revolution, largely they were dependent on militia, or soldiers that were raised by the states. There wasn't this huge American national army in the fledgling early years of our nation. So largely they were dependent on these existing militias, which were defined usually as unofficial armies. And the way Amendment 2 is set up, I find that people tend to ignore the first part. The first part declares that a well-regulated, and that means controlled, a well-regulated militia is necessary for a free state. And they're referring, of course, there to the fact that without that militia, we would not have been able to defeat Great Britain. So absolutely, it's necessary to fight for our freedoms. But it then goes on to say, therefore, government cannot abridge or limit people's freedom to bear arms, which is translated as guns. So it's important that you're aware that the Second Amendment begins with a well-regulated militia being necessary for a free state. It sets up this idea, which some people have interpreted it this way, that because of the necessity of a militia, or perhaps that this section about government not being able to abridge people's freedom to bear arms might apply only to that militia that they mentioned in that first clause. So that's why there's been such a debate, even since the very beginnings of the nation, about how much the Second Amendment really protects. And there is, of course, right there in the amendment, this phrase that a well-regulated militia. So this idea that you can just have any gun, anytime, anywhere you want is certainly not what the Second Amendment is about. Generally, this has been interpreted, and remember, it's the judicial branch, the Supreme Court, that does that interpreting. Generally, over time, this has been interpreted to allow both the national government and the state governments to pass regulatory laws that limit or control in some way who it is that can get, say, a license. So this should be then your state Congress or your federal or national Congress. This becomes dicey when the executive branch, like President Obama, attempts to step in and pass regulatory executive orders. But that's what we are still debating today. This was entertaining, though it's a good example of, I don't think that means what you think it means. This was an entertaining bumper sticker that I saw claiming that the Second Amendment is the only gun permit that they need. And you can see there that it's issued at the very founding of our nation. That's funny, but not accurate. This is not going to work as an argument in court, so be careful of that. Now, the Third Amendment also comes really directly out of some of the events in the American Revolution, which you will hopefully remember. You should remember that one of the most irritating pieces of legislation that Parliament passed was the Quartering Act, which required Americans to house and feed British soldiers. Remember that they had a huge number of British troops in America, whose purpose it was really to make sure that the Americans weren't violating the Proclamation of 1763 and going into native lands. Americans were as frustrated by this as you can imagine, and as frustrated as you would be if you were forced to keep stranger soldiers, like dangerous soldiers, in your home. So because of the Quartering Act led to a lot of protests on the part of the Americans, and that is definitely what the founding fathers, the framers of the Constitution, had in mind when they put this amendment in there. This idea that you absolutely cannot quarter troops in peacetime, and if you're going to quarter troops in the time of war, it has to be done by the official passage of a law at the congressional level. The final one that ties really closely into the American Revolution and their immediate experience is Amendment 4. And Amendment 4 starts with those writs of assistance. And I need you to remember that the writs of assistance were those warrants that the British customs officials passed to stop Americans from smuggling. Remember that Americans were doing a lot of smuggling to avoid paying the taxes that they saw as unfair. And the British were really struggling to be able to collect these customs duties or to collect these taxes. So they began using these writs of assistance. And these are warrants, but they are entirely without probable cause. You don't have to offer any reasonable, that's what probable is, reasonable evidence that you expect someone is smuggling. What was frustrating about these was that they could just do as they please, search anything that they wanted. And as you can imagine, if that were the case, you would be frustrated by that as well. So this is definitely what your framers had in mind when they created Amendment 4, which prohibits or makes illegal unreasonable search and seizures. Search makes sense. You may not think about seizure, but when I seize something from you, I take it. And you should remember from the writs of assistance that some of these customs officials, though not all, when they were in the middle of searching your stuff, they might also take a little off the side. They might confiscate some of it, and there was very little you could do. There was very little legal recourse that you could depend upon because they were law enforcement. So the most important thing that Amendment 4 does is require warrants. And not only do you have to have a warrant to do any searching, the warrant has to be based on probable cause or likely evidence. It has to be signed by a judge, and the judge has to, or the law enforcement official who's seeking to get that warrant has to be very specific about what they're going to search, where they're going to search, and what they're looking for. And things outside of the scope of the warrant are not necessarily going to be admissible. So I remember this because Amendment 4 deals with warrant. Amendment 4 deals with the necessity of warrants and unreasonable search and seizure. Now, a more updated version of this appears when we talk about of course, the NSA spying. A lot of people have argued that the NSA spying program is an unreasonable search, that in fact they're collecting the information from millions of Americans who obviously there was no warrant for that information. But also, the 8th graders just had to write an argumentative essay about this. To what extent does this idea of searching apply to the digital world? So I found this cartoon as an interesting little argument on that issue, and it suggests that absolutely not, that you have the right to say, no, you have to have a warrant in order to search my cell phone. But if you think about it, these are things that the Founding Fathers could never have anticipated. How could they have anticipated the internet and how it has been applied in free speech? How could they have anticipated an assault rifle that's capable of firing 100 rounds in under 10 seconds? And how could they have foreseen this? When we used to think about seizure of property as actual things, but now think about this, allowing a cop to search your cell phone also and your Facebook account, something like that, is also in itself a search and seizure. So those are the three that really deal with specific events from the American Revolution. 2, 3, and 4, you should be able to tie them very, very specifically to events in the American Revolution. Now, 7's kind of a weird one. It's kind of hanging out there. It didn't end up in the rights of the accused because it doesn't really deal with these criminal cases. It deals with more like civil cases. So I told you that civil cases, divorce and divorce settlements fall under a civil case. Wills and testaments, the probate is what they call it, but the process of deciding who's going to receive what under the terms of a will, that's a civil case. When people sue each other over things that are not criminal, think Judge Judy, all the things people sue each other over that are not criminal, that's civil. So that's, I'm assuming, why your book decided to leave this out of the idea of the accused, because when you're in a civil case, there's not so much an accused person as there is two parties who are fighting for most often a piece of property. But what 7 does is it guarantees that you can have a jury trial, that you also can enjoy the protections of having that fair and impartial jury guaranteed by 6. Remember that the 6th Amendment guarantees a speedy trial, that they can't keep you waiting long, that you will have a fair and impartial jury, and that you will be guaranteed a lawyer, even if you cannot afford one, on what will be provided to you. So this continues kind of that trend in saying that even in civil cases, you can have a jury trial as long as the case is worth over $20. Now, this is a good example of this wording still being relevant to the time of the framers of our Constitution. One thing I read suggests that almost no cases could possibly come to court where people were fighting over less than $20, because think about the fees you have to pay in order just to get a lawyer, and it's going to be very unlikely that you'll sue anyone over less than $20. But this is how it's phrased. A little bit of background. At that time, they were the British were fond of suspending trial by jury, and they would at time try people who had been accused of crimes under only judges. And some of those judges were still kind of seen as loyal to the king, so they were unlikely to give you an impartial or an objective decision. But just for 7, just keep in mind, you can have a jury. That's why I put that there. You can have a jury in any civil case over the amount of $20. So we're going to get into 9 and 10 now, and 9 and 10 really go hand in hand. I saw some people who felt confused as to the difference between them because there are some similarities, but you need to be able to distinguish between Amendments 9 and 10. So Amendment 9 really is saying, but wait, that is not all. Amendment 9 literally says, just because these are the rights that we have chosen to enumerate or list out, there's another use of enumerate, and you're going to see it in 10 too, just because these are the 8 rights that we've chosen to list out does not mean that those are the only rights that are guaranteed to humans. This idea that began with John Locke, this idea that humans had natural rights, part of that was that it wasn't limited to just life, liberty, and property. The idea that humans had a number of rights that were guaranteed to them that could not possibly be spelled out. Some of those that, the tutorial mentioned, the idea that you had a right to marry, which of course is one of the big debates and had been until the Supreme Court settled it as much as it can be considered settled. Remember that when a conservative president is elected, he will have the chance to choose Supreme Court justices as they retire or pass away. So it may very well be that a later Supreme Court case will change the current ruling. The current ruling being, of course, that the states can't prohibit gays from marrying. But this idea that you have a right to get an education. There's been a lot of debate about the right to privacy. A lot of people have interpreted, because you have a right, you have protections against unreasonable search and seizure, some people have suggested that implies a right to privacy, but nowhere in the Constitution will you see that explicitly stated. Now, I want you to think back to the time of the Anti-Federalists and the Federalists, and I want you to remember that the Anti-Federalists, one of their big complaints about this new Constitution was that they feared that the national government was getting too strong and it wasn't going to protect their rights. And they were fighting, and they said, we want a Bill of Rights. And one of the things the Federalists said, I don't want you to think the Federalists are just like, no, we don't like that. The Federalists had a legitimate argument. One of the things the Federalists said was, if we choose to give you what you want, a spelled out list of rights, doesn't that suggest that those are the only ones? Isn't there a danger that if we spell out a list of rights, there'll be this, that someone will interpret that as being those are the only rights guaranteed to people, when they wanted to make sure that every right that just humans deserve protecting was included. So Amendment 9 was this kind of compromise there where it said, look, we openly acknowledge that there are other rights. Even if they're not listed here, humans do have other rights as the courts and the government decides to interpret. Listing these 8 should not be an indication that you should forget all the others. Now, Amendment 10 is fun because Amendment 10 really lays the groundwork and the foundation for federalism. That's why I put that with that big exclamation point. Amendment 10 doesn't deal with rights. It deals with powers. So I can see why if you were confused because it seemed like very similar language. But this is saying that any of the powers, because you're going to look, and when we study the legislative branch, we'll actually look at Article 1 and look at where those concurrent and reserved and enumerated powers are spelled out. You're going to see that this deals with powers, and it says that if these powers were not expressly enumerated, so explicitly, clearly spelled out and listed, any powers that were not spelled out and listed as belonging to the federal government should be kept and retained by the people and or the states. So all of those advocates of states' rights who really want to fight this creep, what they see as a creep of increasing federal power, they want to always defer to this idea of Amendment 10, because Amendment 10 really gives them the opportunity to say, well, if it doesn't explicitly say in the Constitution that you can do this, then you can't do it. Now we come back to that idea of how could the Founding Fathers have anticipated the internet? Everything that's happened over the course of 220 some years since the founding of our nation and the creation of the Constitution, they couldn't have anticipated that. So you can't really argue that just because the Constitution doesn't mention the internet, that there's no place for the Congress to regulate that. But it is the foundation and the basis of this idea of federalism, that if the powers are not enumerated for the federal government, they are reserved. I actually did the hand gesture just then. They are still reserved for the states. This also has that big principle that is essentially the basis of everything we do here, limited government. By saying that if it's not given to the federal government, it belongs to the people or the states, it's going to do a good job of limiting the size of that federal government. So those are your final amendments. Hopefully breaking them down into those 3 chunks helped you a little bit. And make sure you are studying. There's the Quizlet set, which has not just the amendments, but some words, and the HPQ, which you need to do. I'll see you in class.